Hi, I'm Tom King, the founder of Toolkit.law, and we are here today to talk about domestic violence, trauma-informed lawyering. This is such a special opportunity for me today to be here with a good friend, one of my classmates from law school. How many years ago, Stephanie?
Oh, do we have to tell them that? Do we have
No,
to?
we do not. We do not. Steph-
Decades.
Stephanie Neal-Johnson and I both attended Boston University School of Law. Class of 1992, 33 years ago.
Yes,
She,
yes, you told them.
as an attorney, her areas of practice have been in law, public policy, and education, where in her journey, domestic violence has always been connected. And so Stephanie and I, for the next 30 minutes, we're going to talk about trauma-informed lawyering. Now, as a side note, if you go on toolkit.law and you read my bio, you'll see I was the attorney in America that invented online mediation. The reason I did it, turns out, was because of in our jurisdiction in the United States, we have states rather than provinces or regions. So in our jurisdiction, if someone claimed family violence, they didn't have to go to mediation, which just meant that the abuser got to drag the cases out longer and make it more expensive for the victims. And that's how, at least for us in America, online mediation began. This is such a great topic. So Steffi and I are going to talk about domestic violence, trauma-informed lawyering, and how this should inform us on as both lawyers and as mediators. So let's go ahead and get started. And we're looking at the help sheet right now, and everyone's following along, Stephanie. Let's talk about trauma-informed lawyering.
Absolutely. So, one of the things that's fascinating and challenging about trauma-informed lawyering is that when you're dealing with victims of domestic violence, people don't necessarily think of themselves in those terms. Victim, survivor, those words don't apply. And so, one of the things that happens is that you often have to spend time, particularly in my experience with women, just helping them to understand that what they're experiencing is just not okay. And in the process of having that conversation, we have to look at the notion that there's often a power dynamic at play. There's a challenge there, and we have to be mindful of that. We have to obtain the information. We have to really go in and drill down and understand the details of what is going on in a way that is respectful, in a way that often requires you to go at the information from more than one angle. What does that mean? That means that we have to be gentle. That means that we have to be kind. In my experience, that means we have to bring a caring, almost servant perspective to the information to make sure that we are asking the right questions and making sure that we are familiar with the criteria that are required for the jurisdiction in which the mediation is taking place.
And you know what? They don't teach us how to be that by default at law school, do they?
Not at all.
To
Not
be
at all.
sensitive, to be cognizant,
No,
to
no.
think about any of these things, even in family law cases. They don't teach this in law school. And for so many of us, myself included, it doesn't come naturally, does it?
It does not. For me, I'm thankful for ministry. That's a piece that I bring to this when I'm talking to individuals and trying to understand domestic violence and the concerns. And I mean, it becomes so difficult, particularly when you begin to introduce children and try to understand the risks that children are facing and that women are facing, and trying to make decisions that are appropriate to protect their children from physical and sexual abuse while trying to prevent the loss of children. It just is not a true fair system, if you will. And so we just have to be careful to protect and to cover the individuals that we are talking to and engaging with, so that we don't create an environment that complicates the situation. We don't want the increase in incidents of abuse. And so we have to make sure that we gather the compelling evidence that is required, and then go from there, and be aware, of course, of bias. So, we have to take a look at the fact that sometimes the court system is used as a tool of warfare in between parents. Sometimes it's used to fight a battle that has nothing to do with the actual situation. Sometimes we hate to think of the notion of blaming the victim, but sometimes there are times when situations are not mitigated but exacerbated by the parties at play. And so we really have to take an approach to promote violence informed decision making in a way that works well. So there are resources certainly in Texas and Massachusetts and wherever you may be. Check to find out those resources. If they're not readily available, it might make some sense to be an inventor, to be an entrepreneur like Tom and I, and think outside of the box and find those ways within the jurisdictional requirements to support your clients.
Let's move on to the interview. What do we as legal professionals need to know about screening? Uh, I like to say alleged survivors because we weren't witnesses, right? We don't
Right,
always,
right.
we don't. Sometimes when you see the video, you know what happened. When you see the medical
Absolutely.
reports, you got a pretty good idea what happened. Sometimes when it's he said, she said, because I always believe two things are equally horrible: domestic violence and lying about it.
Right, right.
So
So,
what do we need to know about the interview, Stephanie?
well, we need to find out all the W's, all of the who's, the what's, the where's, the when's, the why of each and every single incident. It's really important to encourage note taking and journaling and that sort of thing. We're not God here, so we can't judge, we can't assume, and we cannot discredit anything that is being shared with us because if we do, we're not going to be effective. So as Tom said, this is the place where we have to ask the pointed questions, but not it can't be questions that appear to place blame on anyone. They can't be questions that appear to make people uncomfortable. So with the client's permission, then we're going to prepare the memo for the mediator well in advance. It gives us all a chance to review, to go back, to prepare, to find space, to do all of the things that we need to do to make sure that the process is as smooth as possible.
And you know what? When it comes to intake, if you have paralegals that handle intake,
Right, right.
they need to be just as sensitive to this topic.
Absolutely,
And so whenever
absolutely.
you have your intake questionnaires or forms, and I'll show you on Toolkit.law later in this, we integrate this into intake for family law cases to come up on this because it for me it was such I thought I was such a great mediator until I put on this domestic violence CLE and found out I wasn't doing any of these things about 5 years ago. And so this what every person in your staff who touches this client or this witness needs to always be on the lookout for these topics, right? And
Absolutely.
this can apply to a prosecutor who's representing a victim as well, right? So it's not just private practice. It could be as a public defender or as a public prosecutor. So
Sure.
what do we need to know about custody?
Well, custody is a complicated process. But part of what we have to do is to explore um, the informed decision making process in family law matters. And there are a couple of resources that are here for seeking advice. Certainly in Texas and Massachusetts are they're different. Those are our primary areas, but whatever your province, whatever your country, whatever your legal requirements, is important to make sure that you know the process, make sure that you are approaching it in an informed decision making way so that everything is as smooth as possible.
And so what we see here is a term that's often used in the United States, but for the 80 plus countries who are the target markets of Toolkit.law, because all of those 80 countries have English-based legal systems. In our jurisdiction and in many jurisdictions across the United States, when we talk about parental rights, it's a sole managing conservatorship versus joint managing conservatorship. Just wanted to put that out there. Now, let's talk about rebutting bias.
Sure, sure, sure. So, again, one of the most important things when we're considering rebutting bias is that uh, the domestic violence between the parents is not doesn't 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 have any bearing on the custody. That custody is a separate issue, and we have to treat it as such. Sometimes there are false allegations in the midst of this abusive situation. And even though we say mothers here, it's not limited to mothers, although we know that women do face domestic violence, often at very high rates. We also have to be aware of the fact that the father has a role to play here, and we can't ignore that. So, to the extent that sometimes there's a victim responsibility for abuse, as hard as that to say and to reflect upon, these are the evaluations that we have to do to make sure that we are selecting an appropriate, trained, certified evaluator to overcome the bias is real. Bias exists. It's hard to say, it's hard to think about. As Tom said, we're not taught necessarily in law school to do these types of evaluations, but this is important.
What's the last box in green at the bottom of the green column?
Well, we're talking about, once again, making good decisions. We're making sure that we are approaching intimate violence partner intimate partner violence rather in an informed way. And so we need to seek out technical assistance. We need to not be afraid to reach out to the resources that we have, even as attorneys and mediators. We need additional support. And here are a couple listed here, but we certainly encourage you to take a look at those resources that are available in your various jurisdictions, counties, provinces, whatever the controlling authorities are where you are in making these decisions.
I thought one thing that would be helpful now is because we're all watching this on the Toolkit.law platform. And as you may know, this is over 1,500 legal tools, calculators, and utilities that our 16-person team custom designed, all original content over 3 years of development. So if you go to our tools, if you go to our homepage and you click on suites, it'll take you to our 13 different suites. And if you go to mediation, you'll see a mediation suite. And within the mediation suite, you'll see a tool called Mediator. Of course, you can also get to this through the tools. There's a number of ways to do it, but we've created a mediation memorandum generator. Okay. And in this mediation memorandum generator, we have the opportunities to create the mediation memorandum to document all these details. And you'll also see that on child custody cases, we also have it there. If you go under so if I go back to the home page under tools, if I go to it's the divorcer tool, one of my favorite tools, not because of the subject matter, but because it streamlines and consolidates a lot of stuff. So for instance, you may find that you go into one of these cases and here are the concerns, and see how our software flags it automatically. Are there abandonment concerns? Is it acknowledged, investigated? Is there adultery, criminal activity, domestic violence, acknowledged, alleged, convicted, investigated, not applicable, or none? Okay, so our software documents all this, and then of course it generates the memorandum for you that you can then turn into the mediator. And we even put a nice cover sheet on it. So be sure when you go to toolkit.law, you can go to the suites area and you can go either under family law suite or the mediation suite, and you'll find the divorcer tools and the mediator tools to put together your mediation memorandum. Let's go ahead and now jump to my side of the column on page 1. And this is the MASIC 4 or the MASIC scale or standard or benchmark. And this was such an epiphany for me, Stephanie. This is
Mm.
what really got me starting online mediations in America, and also
Sure.
was the impetus for doing some software, some guardrails for how to when you're going to put together materials as an attorney, are you also addressing these concerns? Because you're always preparing for final trial and then working backwards, just like whenever you train, you're training for the marathon of 26.2 miles. But you know what? You may
Sure.
only run the half marathon. You may instead settle the case before mediation, but you
Sure.
want to be fully prepared. But that also means you need to literally change the DNA of your intake process as a sole practitioner and as a law firm or as a mediation practice. So, what is the MASIC 4 standard? It's a standard that's it's a screening tool to make you aware of the things to ask for. Okay, so when we are over here, so some victims of domestic violence may not believe that they are at risk. Okay, and the mediator needs to assess that because what did we find out from research in our jurisdiction in the state of Texas in America? We found out that the aggressors, the bullies, the beaters, usually, but not always men, they want the divorce to go as long as possible because they want to sit there and have their day in court to tell the judge why she deserved it. That's literally their mindset. And they're
Yeah.
looking to maintain their control. The worst thing for them is when the divorce is finalized and they no longer have control over that partner or
That's
those
right.
children, right?
Right.
So
That's right.
and so they were expecting women, maybe with a child with them at the mediation, like an infant, or at daycare, sitting in one room across the hallway, knowing the abuser was right across the other side of the hallway and may come busting down the door and shooting and killing her. And those things were happening. Or he would be waiting in the same parking lot on the same floor afterwards. Okay. And so
Yeah.
in some jurisdictions, we allowed that if it was in some way validated, they weren't forced to go to mediation. Well, what that meant, because they didn't think before 2017, they didn't think about doing it virtually. They only could think of it in the real world, right? Well, what that meant was the case just got dragged out another 7 or 8 months, became way more expensive. So this intake process was developed. There was forms that are submitted in advance, and you screen these things out. Whenever I do a mediation, I always require my attorneys to address that in their mediation memorandums. In family law, only 10% of family law attorneys in my jurisdiction do mediation memorandums. Talk about you should use, if nothing else, talk about great uh, malpractice insurance. Always do a mediation memorandum. Always do a mediation memorandum. And then use that as exhibit number one if a grievance is ever filed against you. And if you want one to look really organized, use the one on Toolkit.law and give us feedback on how to improve it by clicking the feedback button. But you need to have an intake process. You need to bring it to the attention of the mediator in advance. I had one about a year ago where it was horrible, horrible circumstances between the two sides. And neither side had done a mediation memorandum. And the husband had murdered the wife. He was in prison, and both sides of the family that were trying to adopt or take over the children, and they had made me aware of the murder that was broadcast live on Facebook.
Oh my God.
Okay, true story.
Unbelievable.
True story.
Unbelievable.
And
Oh,
so
yeah.
you have to get you have to help your mediators meet their obligations, right? So
Yeah.
you need to do an
Absolutely.
intake process. You need to have sample questions, um, and you need to be aware that accommodations will vary under circumstances. But I am the biggest believer, and judges don't believe this. Judges are still requiring in courtroom dockets. Man, if I was running for judge, I call myself Tom Everything Online King. Vote for Tom Everything Online King, except for
Makes a difference.
except for certain circumstances,
Yeah.
because I've done temporary order hearings from my RV traveling through national parks in Canada, and you couldn't tell, and it was just as effective because in mediation moves faster when you're online, not slower. I've had a person mediate from a forklift when he represented himself, and he drove the forklift the whole time. I made him stop when it came time to sign so he wouldn't spear somebody. But the point is, the accommodations now exist. whether it's Zoom, whether it's Microsoft Teams, whether it's freeconferencecall.com, whether it's Google Meet, which happens to be my favorite one because of the lower bandwidth requirements and no software requirements. There are 4 or 5 great tools out there, and if you go to toolkit.law and you look, you'll find the technology listing right there. Go under conferencer.com, and we give you access to all. In fact, I'll show that to you people. I'll show if you go to toolkit.law and you go under tools, and then you go under conferencer, it's all the resources that you need. Okay. It even allows you to test your equipment, right? So you can test your equipment to see if your audio and your video is working. Because I'm using my camera now, so it's not letting me do it. But we provide all this. We list all the services that you could take advantage of. Amazon has a good one. There's lots of great places that do lots of great videos. So Zoom is not your only choice. And by the way, now it's called Zoom Workplace. It's not just Zoom anymore. It is way more than just video conferencing. Google Meet happens to be my favorite one. But you have to work this into your process. You have to start requiring mediation memorandums if you're a mediator, and you need to give them the guardrails to address these topics. But otherwise, if you're the attorney, you need to do this one to always protect yourself, to always from a grievance or a complaint to your regional bar association, but also to be prepared. And I always include an exhibit list and a witness list to show them that I'm already ready for trial. Okay. But the fear and the force is always a big concern. And remember, we always want to empower a victim who affirmatively wants to mediate, right? But you have to make them feel safe. I don't know why some lawyers still think they need to have their client in the same room. I can
They
put them
don't get it.
They don't get it. And I can move so much faster. I'll jump into a room and they'll go, "Oh, I forgot to ask one last question. I forgot to ask in the other room whether there's anything that we just discussed that needs to remain confidential. I'll be back in 10 seconds." 5 seconds I ask, 10 seconds I'm back. Well, if I'm in a physical room, I still haven't gotten out the first door and walked 20 yards or 15 meters down the hallway to ask, then come back. I find online mediation is faster, and I settle 93% of my cases on final orders. So I happen to think that online mediation is better for just about everything except a jury trial. Okay. But remember, you
I
want to empower
don't
the
like
victim.
those.
You want to empower the victim who wants to resolve this case. But they have to feel safe. Well, where would they not feel more safe than if they're in their living room of their own home by themselves, right? With the ability to go to a separate breakout room with their attorneys. Okay, Stephanie, let's go ahead. We're going to flip sides. We're doing great on time. Let's go ahead and
Excellent.
flip sides to the other side of the help sheet. And I'm going to go back into Zoom. And you again are going to take the left column. Here we go. So let's talk about conducting mediation.
So, as when we think about conducting mediation, the good news is that um, any party, prior to everything being finalized, may file a written objection to the referral of the suit for dissolution of a marriage. And so, when that happens on the basis of family violence, you know, the after the objection is filed, the suit may not be referred to mediation unless a hearing is held and the court finds that the evidence does not support the objection, that a preponderance of the evidence does not. As soon as they're referred to mediation, then we have to think about it a little differently. Then the court will order appropriate measures to ensure the physical, emotional safety of the party who filed the objection. And as Tom said earlier, this is really, really, really important. I was dealing with a couple. They were holding hands the whole time, and it was clear that the safety wasn't there. I had two reams of hospital records for the woman, and So it's really important that that space be made, that the face-to-face contact is prevented, that the separate rooms occur, because you really are not going to advance the process, particularly where we are dealing with coercive control that Tom referred to earlier. Um, so appearing via Zoom or hybrid mediation is a very, very good idea. We want to make use of technology. As Tom said, it is fast, it is private, it is comfortable. And as long you're not going to make as much progress when the parties are not comfortable, particularly those who are in the process of surviving and healing from domestic violence. So emails and DocuSign, all of that is very, very important. If for whatever reason in your jurisdiction, in your province, wherever you are, if for whatever reason mediation must take place in person, then we have to think more aggressively about physical engagement and preventing it. So we want to consider such things as making sure that people arrive and leave at different times. We want to make sure that we're considering where the entrances and the exits are to prevent overlap of attention or engagement. We want to make sure that they're separate spaces. We want to make sure that there are separate restrooms. I mean, if it's possible to get them on in different buildings that are connected somehow, strategically placing people so that they will not interact is important. And then, of course, domestic violence really can become an end. And so we don't want murder. We don't want people to be killed when they're moving to and from spaces. We could tell stories all day about those kinds of situations. So believe it or not, in-person mediation is that much more complicated because we have an obligation to protect those that we are trying to work to a solution with. So, but as we as we do the in-person mediation, we also have to be mindful of the screening and the communication that must take place. So throughout the mediation, we have to make adjustments. We have to remember that people, this is an emotional engagement, and some of the survivors don't understand the full scope of the danger that they may be facing. We also have to be mindful of the behaviors, of the engagements, of the kind of information that we're learning and is being shared with us to determine, as we said in law school, right, Tom? We got to spot the issues to make sure that if there was domestic violence that was not initially disclosed, we still take appropriate steps to manage it, considering the conduct and the reactions that people are having towards one another, the tone and the word choice that we then choose to be a resource, to be a healer, to be an encourager, to in fact bring the mediation to a positive conclusion is important.
Yeah, and I just did a search. I just found this. It happened 2 days ago. Wife shoots husband after
Uh,
finding divorce papers were filed. This happens all the time.
yeah, it
Usually it's
does.
the other direction, right? Usually it's the other
Mhm.
direction. It's usually male and female. Okay. But here's just an example that happened 2 days ago out of some part of the United States. And we also have to remember that in certain countries, they probably still haven't approved online mediation, right?
Right,
So for our
right,
80 plus countries with English-based legal systems on earth that are the target market of Toolkit.law, you have to know what the laws are, and you also maybe want to be the attorney that did what I did in your jurisdiction and ask the judges to let you do a trial case, to have a
right,
mediator set up a
right.
Zoom mediation as a test case. Because to my knowledge, never in the United States has a mediation in the last 8 years been thrown out because it was online. Because
Yeah.
if you can do online hearings like they did during COVID, then
Oh, absolutely.
you can do online arbitrations, you can do online hearings, you can do online mediations. What's next, Stephanie?
Well, let's talk just a little bit more. We'll talk a little bit about the just non-disclosure of information, right? There are going to be times where, for the health, safety, liberty of a party or of a child that 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 an affidavit or pleading must be submitted under oath, indicating the specific information that could become a problem for that family. In other words, if the disclosure of specific information could cause health or safety concerns, it must be sealed. It cannot be disclosed to the other party. It cannot be disclosed to the public. So, after a hearing that takes specifically into consideration those health, safety, or liberty concerns, then the tribunal might order a disclosure of information that determines the extent that that information needs to be used in the interest of justice. It's a very, very delicate balance. But we want to make sure that wherever those circumstances occur, that we work to prevent the disclosure of information in those exceptional circumstances.
And of course, we need to remember that mediation is confidential. But the other thing that sounds rather that sounds like does not need to be even covered. You need to make sure that the two parties are not communicating with each other directly during mediation.
Yes. Yes.
You have times when they're working out their own deal, texting each other,
Right.
and I say,
Right.
and I find out, I go back to the other room. Are you aware of the messages that your client just sent over the last 15 minutes to the party you're negotiating against? And the lawyers freak out. Or
Right.
it turns out that one party is texting threats to the other side during mediation. You need to have a standard introduction process and rules that you go over. Um, I have an automatic system. Whenever you book online, it automatically sends out links to the rules and the requirements, but you need to cover those briefly up front. Okay. Um,
Absolutely.
let's go ahead and switch to the last side. We're doing great on time. We've got about 6 minutes left. So I'm going to go ahead and share my screen again as we finish the last here and share. Here we go. So they need to be safe and workable orders. So what is, the parties need to agree to a main medium of communication. Okay. Or put differently, this column is about what's the finish line, whether it's on temporary or final orders. Are you working towards a mediated settlement agreement that in the United States we call an MSA? And then on that, the final order or the temporary order is based. Because remember, on an order that is based off mediation, you can expand upon things, but they need to be consistent. You can't add things in many countries from a mediation if they weren't addressed in the mediation. You can do supplemental agreed orders, but they need to be consistent. But remember the finish line, right? They need to agree on a way to communicate. There are three great platforms in North America that I'm aware of. One is called Talking Parents. Another one's called Our Family Wizard. And the other one has a silly name, but really is a good platform called App Close. I have no idea which executive
Creative people, Tom. It's okay.
which executive was at the bar writing this down on a napkin. Oh, APPCLOSE, App Close. You need, and I always put the language in which they're required to communicate. Because if you have two parties that speak a language other than your jurisdiction, you always want it to be in that language that the judges can read. Found out there's one, I believe, that was, well, the language doesn't matter. He was cussing her out all the time, and it was not one of the top five languages. Okay. And judges had no idea what was being said. She goes, well, can't you read it? He goes, no, I can't. No, I can't. Right. So I always put the language that the two parties shall communicate in when they use such a platform. Okay.
Yes.
Parties need to agree to maintain a single topic message conversations, one topic per thread. Okay. so that you can go back. Remember, on these platforms such as App Close or Talking Parents or Our Family Wizard, once you say it, you can't change it or delete it. So as my dad said, who also graduated from our alma mater, law school,
Mm-hmm.
Stephanie, he said,
Mm-hmm.
say it with chocolate, say it with sweets, but for God's sake, don't say it in ink. Right?
That's the truth. That is the truth.
Right. Well, you're saying it in ink when you use these apps, and you have to put in your mediated settlement agreements, the parties shall only communicate any type of communications through this medium, and it shall be in the language of the jurisdiction. So a great example is in Pakistan, number 3 in the world by population of English speakers. All law school is in English. All court hearings are in English, and all laws are published in English and in Urdu. But some don't speak English. They only speak Urdu or Pashto or Punjabi. Well, you got to pick a language that does bilingual to be a judge in that country. In Pakistan, you have to be bilingual in Urdu and in English. So you need to pick the language that the judges will recognize. And you know what? If it's not an easy language for you, then maybe that's even better, because it'll be harder for you to cuss at the other person. Okay. Okay. The parties. So, oh, 1, 2, 3. So the parties need to agree to ensure their messages remain concise, free from commentary. They need to agree to acknowledge receipt of messages. And you use these communication platforms for 3 things: for messaging, calendaring, and reimbursements. Okay. So if it's a family law matter and one party does the medical expense that's supposed to be shared, they post the bill and they ask for reimbursement of half, and they include the receipt, right? Okay.
Mhm.
And for all the calendaring, so the other side can't say, well, you never shared with me the doctor's appointment or the teacher's conference. Well, if you calendar everything, it's your best defense if they want to bring you back to court. Okay. We want safe communication provisions, right? So just like we were talking about here, okay, I just covered with that, with those. If I was king for a day in your jurisdiction, I would require one of these platforms for every family law case, even if you two get along, even if they get along, because it's so much better than saying, wait, did I send that to the other party in Facebook Messenger or in Snapchat or in email or in GroupMe or in text
So
message,
true.
um, Apple iMessage, whatever platform? If you have it all in one place that's built to accommodate these buckets of communications, calendaring, and reimbursement, most of these are free. um, the one that I like the best is Our Family Wizard, which in the United States is about $150 per party per year. But the way these other platforms get you is they're free to use, but when you want to print these out as exhibits, all the communications and the calendar and the reimbursements, they nail you on they really get you on the cost per page, and that's where they make their money.
Mm,
We need to have safe exchange options, right? What do you do
sure.
when there's
Absolutely.
family violence involved and you have to have an exchange of the children uh, per a visitation schedule? Public places, police stations, who can be there, who can't? Can one party get out of the vehicle? Can the other not? What if the other party's not allowed to get out of the car, but it's a snowing blizzard or it's a pouring
Right.
rain? What do you
Hmm.
do? Are there reasonable accommodations, right?
Right.
And most police stations hate to have an extra big parking lot just for exchanges. But that's where a lot of these exchanges are occurring, right? Exchanges at school. Can they come into the school building or not? Okay. And you need to remember that if you have personal struggles, there are a couple resources that I love, but but in many of the world's jurisdictions, they're called batterers, right? The people
Right.
who
Right.
physically attack the victim. Okay. And in the United States, they're called BIPS programs, batter intervention and prevention, batterer intervention and prevention programs, BIPS. It applies to criminal law and it applies to family law in many states. Those are how we divide our jurisdictions in the United States. Um, but there's also one that I really do love, and it's called Celebrate Recovery. In Celebrate Recovery, you may not be dealing with the issue of, I'm going to celebrate. I should have had this ready. CelebrateRecovery.com. Celebrate Recovery. I really do want to get this on the screen and share this with everybody. There it is. Celebrate Recovery in the United States is a national program that's free with over 2,000 locations. And in my city of Houston, which is the fifth largest city in North America, they have 40 locations locally. And this is not for family violence. This is not for sexual addiction. And this is not for addiction of any type. And it's not for criminals. But for the other 85%, we're messed up too. Right, Steph? Right,
We got
Stephanie?
stuff. We all have stuff, Tom.
I mean, I tell you, you're messed up all the time, right, Stephanie? And you
Well,
tell
Tom,
me,
and we know this is a mutual thing. We got this.
we know this is such a mutual, we know this is a mutual thing. And I will tell you that Celebrate Recovery was so helpful to me when I went through my divorce. Um, and I don't know if it's online in other parts of the world. If you're in the United States, whenever I have family law cases uh, that 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 deal with children, I require my clients do 12 of these and document them because they're free. Okay, so Celebrate Recovery is a great program. If any of you in the United States remember the book called The Purpose Driven Life by Rick Warren
Oh yeah,
about
of
15 years
course.
ago, I mean,
Mhm.
sold like 15 or 20 million copies.
Yeah,
So
yeah,
many, he had so many seminar offshoots and work group offshoots of that, workbooks, courses. They're the ones who created the Celebrate Recovery program. So it's not listed on here, but consider celebraterecovery.com. Again, it's not for recovery from substance abuse. Okay. And they break into male and female groups separately. They're almost always held at Christian churches because it is a Christ-based faith program. So you should be aware of that. So if you're a Christian and you're open to that, or you're agnostic, or you're atheist, trust me, it can't hurt. Okay. Um,
yeah.
anyway, so that's really what Steffi and I wanted to share about family violence. Do you have any, we have about a minute to wrap up, Stephanie. What do you want to close with as you close us out?
No, I think it's important that, in as much as this work feels difficult, to understand that we play a role in in the recovery, in the potential trajectory of a family's life. We want to make the difference, and we can make the difference in what we do with our care and, frankly, our love and concern, understanding that there's something bigger than us involved in the circumstance, and that the children's lives and the lives of the family and the generations to come depend upon what we are doing in this setting, in this circumstance right now. And so, in as much as it feels hard and arduous, remember that it's more than just the work. It's really a calling.
That is so true. I want to share one last thing on Toolkit.law. Remember, it's only $100 per year to get access to all the 1,500 legal tools, calculators, and utilities. I don't think I'm sharing my screen yet. Am I? Nope. Okay, here.
Yes.
Okay. Am I?
Yep.
Okay. So if you go into the tools section, we created a page to consolidate all these things called Improver. As you notice that every page ends with the letter R. And if you go to Improver, we have all these resources to improve yourself if you want to do alternative dispute resolution, if you have alcohol problems, if you have anger management problems, if you need blood alcohol testing. We will soon be rolling all this substance abuse testing for 6 continents out right here on Toolkit.law, where you can pay for the substance abuse testing and get it done on 6 continents. We have resources for domestic violence. Okay, you can prove you can improve how you get through law school. Man, why wasn't this there when
I know, Tom. Come on now.
okay? And so narcotics help, parenting courses. There are now some great programs on pornography addiction, which in many cultures may still be a very taboo subject. Um, Uh, anyway, so I encourage you to go to toolkit.law, go to the tools section, and go to the improver page, and you may find resources there that were helpful. Also, under tools, we talked about it before, the mediator page. And as you prepare for your case in general, going to the litigator page. So it is great to use this as an excuse to get together with my lifelong friend, Stephanie Neal-Johnson. Stephanie, thank you so
Thanks,
much.
Tom. Thank you. Thank you.